Well, good afternoon, everyone. Welcome to this webinar presented by Beresford Booth. My name is Per Oscarsson. I'm a member of the Business and Real Estate Group here at the firm. And Eli Yim, also a member of the Business and Real Estate Group of the firm, is here. We're going to be presenting today on how do easements affect your real estate. We're really going to touch on kind of three topics generally. What are easements? How are they created? And how can you find out more about the easements that may or may not affect your property? So I'm going to turn it over to Eli to talk about what are easements. Eli?
Yes, thanks, Per. I think easements are one of those legal terms or legal concepts that a lot of people recognize, but they may not fully understand, or you come across them in certain contexts that we'll discuss throughout the course of this webinar. And you're kind of not sure what to do with that information. And so this is just going to be a basic primer, the way that Per kind of laid it out, and want to walk through kind of the basics of easements. I think a lot of times people hear easements, they think of a driveway, or they think of a walking path, or some right to go across someone else's property, and all those things are within the scope of easements. And so we'll kind of touch on those things and a few others over the course of the next 15 minutes or so. The definition of an easement is probably the best place for us to start, and it is the grant of a non-possessory interest that entitles the holder to some form of use or enjoyment of another person's property or another person's land. And so if we were to break that up in a few different sections, I think we get a little more clarity. So there is a grant in most cases. And so that involves a grantor and a grantee of a non-possessory interest. In other words, there is no conveyance of title. It is a right, a non-possessory right. And then the last part of the definition, that entitles the holder to some form of use or enjoyment. So everyone still owns the same land, but the grantee of that right, the recipient of that right, has the right to some use or enjoyment of the easement across another person's land. So that's the definition, the grant of a non-possessory interest that entitles the holder, the easement holder, to some form of use or enjoyment of another's land. And so when we talk about easements, there are really two different types of easements. There are easements appurtenant, which is what we see most often, where there are adjoining pieces of land, and people have easements for ingress or egress, or utilities, or drainage. And easements appurtenant involve a dominant estate and a servient estate, or if we think about it, a benefited property and a burdened property. So the dominant estate is the one that has the easement over the servient estate. The benefited land has the easement over the burdened land. And so when we have these easements appurtenant, these are the ones that run with the land, that pass automatically with the dominant estate on sale. And in most cases, there's some exceptions, but also with the servient estate. Then we have, in addition to easements appurtenant, we have easements in gross. Easements in gross are different in that these are personal to a party. There is not a dominant estate. So if you think about easements in gross as a utility company, they may have an easement across a particular parcel, a servient estate, but they do not possess a dominant estate or some other adjoining land. And so that's an easement in gross. Now, the difference here too is an easement appurtenant, I mentioned it runs with the land, it passes automatically, it's transferable upon sale. But with an easement in gross, that is not transferable by the easement holder. So it may pass to the next landowner on sale of the servient estate, but the utility company, for example, cannot transfer it to someone else. It is held by the utility company in that situation. Okay, so we've got easements pertinent easements and gross. We also talk about easements as far as affirmative easements and negative easements. Largely what I've been discussing so far here are affirmative easements, the right to do something on servient land. And then you have negative easements, which are light, air, view, solar, stream water easements, easements that prevent the servient owner from doing something on their land.
Height restriction might be another one of those negative easements, wouldn't it, Eli?
Yes, absolutely.
Like a height restriction on a building.
Yep. And so if you think about it though, right, it is something that prohibits, this is where the negative comes from, prohibits the servient owner from doing something as it relates to some of those types of particular instances, like a view easement, like a height easement, stream restriction, or light, air, solar. So that's the negative component for a negative easement. And then I think the last thing I would say just generally about easements is something that I think comes up quite a bit as far as people calling in to ask questions, and it has to do with maintenance and repair. And I would just say it kind of seems a little counterintuitive, but generally the maintenance and repair of an easement is the responsibility of the easement holder. And I don't want to go into too much detail on that, but that is something that I think comes up quite a bit when folks have easement issues that they want to inquire about here. So that's kind of the quick run through of what an easement is. And Per is going to, I think, talk about how easements are created.
Yeah, one more comment on what easements are. Sometimes you could have an easement, but sometimes you could have what's known as a license. Like the driveway is a really good example. You could have an easement to use the driveway. And that right, if it is in the form of an easement, will pass to the next owner who can benefit from use of the driveway. But it's also possible that a license to use the driveway has been granted as opposed to an easement. But the difference is a license is really between the owners, not the properties, but between the owners. So it's personal. It's also revocable at any time by the grantor or the giver of that license. It also ends if the giver of that license were to die or transfer their property, since the license is between the property owners and not the properties themselves, as an easement would be, then the person who benefited from that license would now have to go back to the new owner of the grantor's property and request a new license. It may be identical to what there was before, but now it's from a new grantor of it.
Yeah, licenses are related for sure, and we don't see them as often. I think because they don't come with kind of the same certainty and assurances in some ways, right?
I agree.
The fact that they can be revoked, they're a slightly different animal, but absolutely related because we see them in kind of the same context.
That's right. I would agree. I don't think we see the license very often, and unfortunately, very often the license is oral.
Right.
And so it's entirely possible, even with people that have had the properties for 20 or 30 years, they've forgotten that whether or not one was even granted. They may, oh yeah, I did get a right to use that driveway, but I couldn't tell you when I got the right. Maybe it was a week ago, maybe it was 15 years ago. Who knows?
Yeah.
So it's always a difficult situation if you don't have evidence that an actual easement was granted. So creation of the easement, because it's an interest in land, even though you don't have ownership of it, Washington law, and I think the law of many states, requires that it be conveyed by a deed. And that deed is recorded just as if you were transferring a piece of real estate, buying or selling a house. There is a deed that is recorded in the county real estate records to reflect the transfer of that interest. When there is a deed for an easement, there could also be included in that an agreement of the response that provides for the responsibilities of the various parties. There could just be two parties involved. There could be multiple parties involved in an easement. for a number of reasons. And so they may include in the deed an agreement as to how they're going to deal with it. Eli brought up kind of the general rule that the benefited property would normally be responsible for repair and maintenance. But that could be the subject of an agreement where decisions on how to repair or how to improve, for example, a driveway, maybe the whole thing is gravel, but somebody wants to put it in concrete or asphalt.
Mhm.
Well, there's some cost associated with that, and so there's probably going to be a requirement of a decision to be made by maybe the majority of the owners of the properties that are affected by it. Maybe it requires everybody to approve. So that can be very helpful to have such an agreement in the deed that actually conveys the easement. The deed could be for a separate transaction creating only the easement. Party A and Party B, they never had an agreement on anything, but now they've decided they want to. And so now they do create a document, a deed that conveys the easement. It could also be part of a transaction for the sale of the real estate. And there's kind of a difference because as Eli said, an easement can be granted, but it can also be reserved. So for my example here is, let's assume you have one owner that owns parcel A and parcel B. Parcel A fronts on a public street. Parcel B does not. In fact, the best way to get to the public street from parcel B is to cross parcel A. So the owner of both parcels decides to sell one of them. And let's say they sell parcel B. Well, they're going to give a deed to the new owner of parcel B, and they will probably in the same deed grant an easement across parcel A to allow for the owner of parcel B to access their parcel from the public street. Now let's take the kind of the opposite. The owner of parcel A and parcel B, they now want to sell parcel A and keep parcel B and live on parcel B. Now their deed to the new owner of parcel A would reserve an easement across parcel A for the benefit of parcel B. There are a couple of other ways that easements can be created. One is by prescription, and you may be familiar with the term adverse possession, which is where one person kind of takes control of some portion or all of another person's property without their consent. And after a period, at least in Washington, of 10 years and satisfaction of other requirements, they can now be held to own that piece of property that they're using. A similar thing can work with an easement where one party may use another owner's property for access where there was no easement granted, and they never got permission from the owner of the property that is being used effectively as a driveway or a pathway, but they've now continued to use it and maybe even maintained it to the extent it requires maintenance for that same period of time as an adverse possession to actually own the land might happen. Another one is an easement by necessity, and I'd go back to my example of parcel A and parcel B. Because parcel B does not have access to a public street, there may require a legal action to have a court determine that you have an easement by necessity because you need to have access to the public street. It would be kind of unusual, I think, for the owner of parcel B not to have had access, because typically a title company in the transfer of property will want to make sure that the owner of the property has access to a public street, and they will raise the issue if it hasn't been determined already. So those are kind of basically three ways that the easement can come about. Very often you'll also see them dedicated in plats of a new subdivision or a short plat, for example. Now, how do you find out about easements? Well, as I mentioned, title company, that's probably the best place to find is from a title report or a preliminary title commitment. I think a lot of title companies also offer products that will provide you the same kind of information, because most people will think of a title report as something that you get when you're buying or selling a property, particularly the buyer. The buyer would want to know what kind of encumbrances like easements are there against the property. But it can come up in other circumstances too. Eli and I talked earlier this morning about the possibility that maybe you want to make some improvements on your property. It could be something as simple as landscaping, which I realize may not be all that simple, but it could also be constructing some sort of an improvement. Well, even something as simple as landscaping, depending upon whether or not there's an easement, typically a utilities easement, there may be language in a document that says you're not allowed to do anything, including landscaping, maybe other than putting in a lawn, but you're not allowed to do any landscaping over the area that's affected by the underground utility, because the utility company may have to get in there and they could potentially destroy the landscaping that's done, and they certainly don't want to be responsible for it. So there is a condition often put into those documents that restricts or eliminates your ability to do anything on the affected property, and hopefully it's only a small, a strip, not a large section of the property. Another thing is just physical inspection of the property. Looking at it, it's not going to tell you, is there an easement? For example, going back to our parcel A and parcel B, there's a driveway on parcel A. It serves the garage on parcel A. But from the street, you may not be able to tell whether or not it serves a garage or anything else on parcel B. So if you see the driveway, again, it doesn't necessarily mean that you've got an easement there, but it raises the question that you need to ask, well, is there an easement for that driveway to benefit parcel B? Or maybe it's just a license. And I'm sure if you ask, they ask the owner of parcel A, which is probably the third way, is asking property owners who may or may not be affected by an easement, is there an easement? And if so, where did it come from? But you use the term license, they may not know what that means. But the general question, how do I, as the prospective owner of parcel B, know that I have a right to use the driveway that is on parcel A and appears to benefit my property or the property that I'm intending to buy? So, and there may be a lot of easements, such as utility easements. Even by looking at the property, you won't know.
Yeah.
Hopefully those are the subject of an easement document that was picked up on a title product by a title company, whether it be a title report or a preliminary title commitment that is shown that shows the easement. And you'll want to take a look at those documents, because it is not unusual that a document shows up on a title report. I would not say that it happens regularly, but it does happen where the easement does not affect the property. Something in the legal description of the property is incorrect, and it can be significant. I saw one within the last year where there was an easement granted, and they said, "Oh yeah, it affects the property." Well, when you actually look at the legal description on the property that was affected by that easement was located about 20 miles away in a different city. And I believe it was in a different county as well. So you really do want to take a look at legal descriptions that are in the documents granting an easement. Sometimes, unfortunately, you can also see in a document, particularly I think some of the older documents that created easements for utility purposes, and they were done to the utility. But you'll see language that says, I'm granting an easement for where the utilities are located, which assumes that the utilities are there when the easement is actually granted. But you have no idea, by looking at the document, assuming the legal description of the property is correct, you have no idea where on the property that easement may be located. It may be located along a boundary of the property. It may run right through the middle of the property, or it may do both. And so it is important to try and get a look at whatever documents there may be that reflect, hopefully, a good description of what the easement is for and where it's located. Yeah. And what the easement is for, the purpose of it, can be very important as well. For example, you've got an ingress and egress easement, the ability to get in or out of a particular property. It may not give the right to do anything else. And I think, I haven't seen any cases on this, but it seems to me that if someone were to park on an ingress egress easement, they're potentially interfering with the use of the easement, because it's for getting in and getting out. It doesn't allow for parking, doesn't allow for blocking it. So it is important to try and get as much information about the easement as you can, just because you may never need to know that information, but it would sure be helpful to have it at least as early as you can, just in case, because it may turn out that at some point having the information may be very time sensitive.
Well, and Per, just to piggyback on a couple of things, I think I actually have come across, for example, in a commercial property context, where absolutely, like there were different express easements that either were or were not granted for ingress and egress, and then for parking. So there was absolutely an easement for ingress and egress, but parking was a different matter altogether. and so, you know, those two things were treated as mutually exclusive as far as easements go. And so, I mean, I certainly would be wary if the easement is for ingress and egress, that if you're parking and obstructing that passage, that would be a violation of the easement for sure.
Right.
And just to pick up on what you were saying about title, I also have come across within the last, I don't know, 6 to 12 months, title insurance support where maybe there were a handful of easements that were part of the report that had to do with parcels in entirely different parcels in entirely different part of town. It had nothing to do with it. But again, it kind of behooves you when you have that kind of a document. They've done a lot of the legwork for you to either review it yourself or have work in tandem with an attorney to review the easements, make sure you understand what is and isn't applicable, what rights you have or don't have, and kind of work through them so that you know what you're dealing with. And I think, Per, you touched on this too. I mean, if you're not going to do a title insurance report, you know, you can always kind of try and slog through the public records and search for recorded easements. And again, you mentioned visual red flags, and I think a lot of times I've had other issues come up where, you know, you buy a property and there's, you know, a well-worn path, let's say, that across part of the property, sometimes you might see it for beach access, for example, across someone else's property. It may not be definitive, it may not be an easement, but it gives you a visual red flag that you're going to want to maybe check out and see.
Right.
And I know with the different types of easements you talked about too, one thing that comes up as well, particularly with prescriptive easements, which as Per mentioned, you know, a lot of the same elements that you would see with adverse possession, except we're not talking about possession, we're talking about an easement, so a non-possessory interest that with a lot of the same elements, that it's been continuous use and actual and hostile, that permission, if it's permissive use, that defeats a claim for a prescriptive easement.
Right.
And so again, another thing to kind of explore as you kind of do your legal analysis of easement.
And there was another thing as you were talking, I was thinking about that you may or may not notice by looking at the property, and it actually came up here within the last couple of years, where there was an easement for utilities that was granted and very nicely described. The problem was that some of the utilities were not within the easement.
Right.
There was an angle in the easement, but the utility kind of cut the corner so that part of its system was outside the boundaries of the easement, and that can become a problem both for the owner of the property during their ownership, but it can also become a problem when they go to sell the property.
Right.
Because there could be some significant issues. It may be as simple as one option is eliminating the first easement and then describing where the system actually goes, and doing a new easement document.
Mm-hmm.
But changing an easement requires all the parties involved to agree and to get the document that does that. Because one party can't just decide, hey, I don't want this easement anymore running across my property. I'm going to say, hey, you can't use it anymore. It doesn't work that way for an easement.
Right.
And it may be very simple for the parties to agree. It could be a knockdown drag out, depending upon what the issue is and how significant it's affecting the property.
Yeah, I think the tricky thing about easements too is that they can be complicated, but they can also be personal, right? Like a lot of real property issues where they involve someone's home space, their residence, or if it affects their property value, they take it personally, and
Yes.
and so it's not just complicated sometimes weighing the elements or the factors at play, but it's also personal, and so we totally understand that, and it's just another thing I think when we talk about easements that we need to be wary of, that the stakes feel very high for a lot of people.
Right. Well, did you see whether we had any questions from anyone? I didn't see anything.
I didn't. I think you preempted all of them, Per.
maybe together we preempted them.
Yeah.
Well, we'd like to thank you all for joining us, and hope you'll join next week at the webinar that the firm presents. And we hope you have a great rest of the day. Thank you.
Thank you.